Welcome, and we're ready to start our webinar. My name is Elaine Eizelman. I'm Assistant Director with the UAW FCA for General Motors Legal Services Plan, and we're here today to talk about trusts. We've received a lot of questions from a lot of the viewers out there, and we hope to answer as many of those as possible. I want to remind you, if you have a specific question, we encourage you to call 1-800-482-7700 and open up a case. An attorney will be assigned to you and help you with your matter. It gives me great pleasure to present our panel today. Carolyn Bernstein and David Savard. Carrie earned her law degree from the University of Wisconsin in 1980. She worked for the former Legal Services Plan for more than 25 years, and today she works as the managing attorney in the New Plan's Saginaw office. And in addition, Carrie's won several awards for contributing her time at the Legal Services of Eastern Michigan, helping low-income clients. Welcome, Carrie.
Thanks.
And next to me is Dave Savard. Dave's first job with the UAW was as a proud member of the UAW Local 372 at the old Chrysler Chemical Plant in Trenton, Michigan. Dave worked there while he was attending Eastern Michigan University. He earned his law degree from the University of Toledo in 1982 and worked for the old Legal Services Plan for more than 30 years. Today, Dave's the managing attorney of the plan's Wayne, Michigan office. Welcome, Dave.
Thank you.
And both Carrie and Dave have extensive experience helping UAW members with their estate planning issues, and we're so glad to have them here today and answer everybody's questions. So let's get started. A number of people contacted us and said, everybody's telling me I need a trust. And they get flyers in the mail, and they know we've talked about it. We all get them too, and invitations to dinners. And so, Carrie, why is everybody telling me that I need a trust, and what's behind that?
Well, there's a lot of money behind that, and that's the honest truth. So people are getting flyers, they're getting invitations for free meals. And when you think about it, when was the last time you ever got a really free meal? So if you show up at a seminar like this, chances are they're going to be gathering your financial information and trying to sell you an expensive trust. And they don't really tell you all the ins and outs of trusts. They try to scare you. They try to give you some false information about how much money it's going to save you. And so you're better off if you contact us. And again, you can have your own estate plan set up where we can look at the specifics of your case and give you some better information.
I know people make a lot of money off trusts,
Right.
but it's not just in the drafting of trusts, it's in the administration of them as well. Is that true?
Well, that's true. I think a lot of times people sell you on the idea that once you spend a little money up front, having a trust is going to save you money at the back end. But if you think about it, when you die, you're going to have this complex arrangement. You're going to hand that complex arrangement over to your family. They're not really going to understand it unless they have some legal advice. So chances are they'll probably have to hire an attorney just the way they would if they opened a probate case. Chances are they're going to pay the same amount in creditor claims, your funeral expenses, the costs of administering your house. They got to pay the utilities and the property taxes. Those are just expenses of owning a house. So those expenses kind of balance out. And yet these trust seminars don't mention those things to you. They just imply to you that it's going to save you all kinds of money, and it really doesn't in many circumstances.
I know you were telling us that some of the reasons they tell people that we need a trust is because there's all these horror stories about probate and about inheritance taxes and the probate that took 6 years and used up all of Grandma's money. So, Dave, can you talk to us a little bit about probate and tell us how it actually works?
Well, probate is the process where your property is passed on to your loved ones. Typically, what goes through probate is property that is just in your name when you die. Mm-hmm. So if the property is just in your name when you die, there's the possibility that there will be probate. Probate, though, is not as complicated and complex as it's often made out to be. Typically in probate, you're looking at some paper pushing, there's some filing of some paperwork, but not necessarily any hearings in court. Most probates are done without any appearances in front of a judge. One thing that's important to understand about probate is creditors can make claims. They can come forward and file a claim against a probate estate. But in many cases, probate's not needed because property is jointly held, for example. I mentioned that if property is just in the name of the deceased, there may have to be some probate. Husbands and wives, for example, they typically have everything jointly held. So when property is jointly held, one of them dies, the surviving spouse just automatically becomes the owner of that property. If estates are small, there may not have to be a whole lot of work done in the probate process. Depends on the amount, for example. And like I say, in most cases where there are properties that are in both names, probate is not needed because the property passes automatically to the survivor without that court process being involved.
You talked a little bit about claims being made in the probate, and does probate limit the time frame for claims?
Yes, one of the nice things about probate court, at least if you want to call it a nice thing, is that there's a limited period of time for creditors to make their claims. That may not be true in the trust administration aspect. So creditors that are known are to be notified, and then there's typically a notification process, maybe a publication in a legal news to give creditors a period of time. That varies from state to state.
Mm-hmm. Okay, well, thank you. That's some good information. Carrie, the other concern that people have is with inheritance taxes, and you hear, so somebody's estate went through probate and the entire estate was taken up by inheritance taxes. Should we be worried about that?
Well, they changed the law a few years ago, and inheritance taxes really don't apply to most people. Most people I know certainly don't have to worry about this problem. If you have an estate that's worth more than $5.6 million for a single person, or $10.2 million, or $11.2 million for a married couple, then estate taxes become an issue for you. But otherwise, you don't need a trust because those taxes don't even apply. So when you hear the horror stories about that, that information is generally just downright false.
Okay, good. For all these seminars where they try to sell us trust, are there things that they fail to tell us, Dave?
Well, the things you need to understand about trusts is it's not just a document. A lot of folks think you create this document, now I'm all set, I avoid probate. But that's just the start. You create the trust document, then all of your assets have to be deposited, in effect, into the trust. We call that funding the trust. So a trust is funded by retitling all of your assets into the name of the trust. Real estate, for example, has to be put into the name of, say, the Jones Family Trust. You would have to get bank accounts into the name of the trust. Oftentimes, IRAs, 401ks, all of your assets, stocks, bonds, for the trust to work have to be deposited into the trust. So trusts like wills, another myth is trusts like wills can be contested. We often see contests in trusts. I had a case not long ago involved 6 different amendments to a trust, and that ended up in the probate court because there were unhappy heirs, unhappy beneficiaries. So trusts can be contested. The other thing that's important to understand is you have to remember to get everything into a trust if you create a trust. So once you've properly funded your trust, if all the assets are in it, then it may well work in avoiding probate. Another thing I should mention too with the real estate matters is that if you put your real estate into the trust and say you want to do a home equity loan or a refi on your house, you'll have to remove that asset out of the trust, back into your name, do your loan, and then you'll have to get it back into the trust again. So there's some headaches and hassles that are involved that maybe folks that are peddling trusts aren't telling you about.
So there can be quite a bit of work associated with it.
There is a lot of legwork, yes.
Yeah, okay. We have a lot of questions about, what a trust is and how they work. And so let's start, Carrie, maybe you can just kind of briefly explain what a trust actually is.
Well, a trust is an agreement that you would establish, and the agreement would dictate how you want things to be managed. So typically the trust agreement appoints somebody to be the trustee who's in charge of managing the assets in the trust, and the trust agreement sets out who the beneficiaries of the trust are as well. So during your lifetime, typically you might be the beneficiary of your own trust. You are probably the trustee of your own trust, and you would manage your assets for your own benefit. Then at your death or disability, perhaps, a new trustee would step in take over management of those trust assets. And at your death, there would definitely be new beneficiaries who would step in and benefit from the trust. So for example, a trustee, you might appoint a trusted person, one of your children perhaps, or maybe a financial institution, which would cost a little bit of money if you ask somebody to do that professionally. But their job is to manage what the trust tells them to do for the benefit of the people you've named. And so in order for them to have control over something, again, we can't harp on this enough, you have to make sure that the assets are transferred to the trust. Mm-hmm. If they're not in the trustee doesn't have any control over those things.
Okay. We've had a few questions from viewers about some specific aspects about trust, and one of them is there a minimum or maximum amount that you can put into a trust?
There's really no minimum or maximum amount. It depends on your circumstances and on your goals with your family. But I will say that if you set up a trust and you're not intending to put much money or property into it at all, you might find that it's overly complex. And then the cost of dealing with it and just the headache of dealing with it and administering it might be worth less than your savings. So it might cost you too much money to bother to set it up under some circumstances. There's no maximum amount, of course. The typical trust is not necessarily going to save inheritance taxes unless it's specially set up if you have a very large estate. Mm-hmm. But for most people, it's not the cost savings really that you experience. To know more about your particular case, you'd really want to call us and go through your circumstances.
Okay. Another question, a couple people have asked this, is how long can a trust last after my death?
A trust can go on for decades after you die, maybe even 90 years. But you have to ask yourself, do you want your family to have to administer a trust for that long? Do you want your family to have to pay? There may be annual accountings that have to be done. Perhaps they have to do a tax return for the trust. And do you really want your family to have to foot the bill for that for decades after you die? So often, you can delay an administration for some purposes. If there's somebody who needs help managing their money, that might be worthwhile doing, but not typically. The cost can outweigh the benefits.
Okay. Let's talk about some different kinds of trusts. There are a number of different kinds, and why don't we start with testamentary trusts? And Dave, why don't you tell us a little bit about testamentary trusts and how they work?
Well, a testamentary trust is a trust that you put within a will. So you create a will, and within that will, you have a trust. So the will is spelling out who gets your property when you die, but a testamentary trust can delay or manage money for the benefit of someone. So for example, you would have a situation, say, with minor children. Maybe you've got a 12-year-old kid. You don't want that 12-year-old kid to inherit money when they're 18, say. Mm-hmm. You might want to delay that. So you could delay the distribution till, say, age 25. And you could provide within the confines of that testamentary trust that the money would be held and managed for the benefit of that child until they hit the age of 25. Up until the age of 25, money could come out, but would have to be for a good reason. Maybe college education, maybe health expenses, or maintaining an apartment, or expenses of everyday life. Mm-hmm. So the money could come out early for that reason. The trustee, who is named in the will as the trustee, would be the person that held and managed that money for the benefit of that child, and would make the decisions based on the confines and the guidelines in that trust, that testamentary trust, as to what's a good reason. That's what we would call the discretion that's granted. And also there could be a trust set up that would be for a handicapped person, say, to delay distribution or to dole out money in small increments so as not to jeopardize any benefits they might receive.
Okay, we have a question that I think is appropriate for what you're just discussing, and here it is. My sister's the beneficiary until my kids are of age. How do I change this once they are of age, or do I need to change this? Is this a good way to go?
Well, if you were to name, say, on a bank account, a sister as a beneficiary, the sister will get the money directly upon your death. Mm-hmm. So right away they get the money. Mm-hmm. Now, maybe the sister's trustworthy and will use the money appropriately, but You have to remember, legally speaking, it belongs to the sister. Now, the sister may intend to use the money for the benefit of, say, another person, a child, but the problem there might be, well, what does she do? What are the guidelines? What exactly am I allowed to do with this money? What's a good reason? If you go with the testamentary trust within the will, that will specifically dictate what the money can be used for, and will provide that guideline for the person acting as that trustee, for the sister in this case, to make sure that they carry out the wishes.
And in the testamentary trust, the money is actually left to the child and not to the sister.
It belongs to the child, but it's being managed by the sister within the confines of the testamentary trust.
So this client might want to consider
Absolutely.
coming in and talking to us about
Absolutely. We'd be happy to
trust.
give us a call. We'd be happy to talk to you about those options and how it could be created and set up.
Okay. Another kind of trust, and Dave alluded to it a little bit, is a special needs trust. And we've had many questions about this, Carrie. And the questions all center around having a disabled child. And people are particularly concerned because the disabled children are receiving SSI and Medicaid benefits. And they would like to know how they can provide for their children in their estate plan without jeopardizing the children's receipt of these benefits.
Right. So a special needs trust is a really good tool that the plan uses often to be able to set up an arrangement to manage money for the benefit of a disabled child. So often disabled children, like Elaine said, they receive government assistance. And if you left them an inheritance outright, that disabled child would have to report that money in their bank account, and they would lose the government assistance that they might rely on for their health care or housing or something. So if you want to try to preserve their right to receive those government benefits, a special needs trust is an option. So this kind of a trust, you can set it up, as Dave said, either inside a will as a testamentary trust, or you could set it up as a separate document called a standalone special needs trust. Either one of them works so that whatever is funded into that trust, that disabled child's share, is to be managed for them by the trustee that you appoint, or the financial institution that you appoint as trustee. And they are responsible for following very specific rules. These rules mean that the money in the trust cannot be used in ways that would jeopardize the child's right to receive those other government assistance programs. And so it is cumbersome a little bit, and you have to follow very clear rules. But the benefit is that your child can have their life supplemented with this extra money and still retain the government benefits.
It's a real comfort, I'm sure, to those parents.
Yes.
Thank you, Carrie. Let's talk a little bit about living trust, which is really the type of trust that we get a lot of mailings and solicitations for. And there's a couple different kinds. Let's start with the revocable living trust. And Dave, could you explain a little bit about a revocable living trust and what it is and how it works?
Right. A revocable living trust is the common trust. It's the most prevalent trust that you'll see. Revocable means it's revocable. It can be revoked. You create this trust during your lifetime. It could be an individual creates it, or maybe a husband and a wife creates this trust. Once the trust is set up, then you fund this trust. So you put your assets into the trust, as we've talked about before. You are the trustee of your trust initially, so you run the show. You have control to put money in, take money out, whatever you want to do with your trust assets. Okay, but you also name a successor trustee. You're naming a person that will take over after you die, typically, but could take over earlier if you became disabled in some fashion, couldn't handle your own affairs anymore. As I mentioned, you transfer the property into the trust, you control it. You and your spouse, if it's a family trust, a husband and wife trust, you get the income, you control the principal, you can revoke it, you have the power to change it, amend it, you have the power to cancel it out, revoke it. We occasionally do that for folks that are, don't want to deal with the trust anymore. So you have full control over all your assets, you take care of it. Upon your death, then it becomes irrevocable. Okay, so once the creator of the trust has died, okay, that's it, it's frozen. And now the successor trustee has to carry out the wishes, give the money over to the beneficiaries that are designated in the trust at that point in time.
Okay. next kind of living trust is the irrevocable living trust, and this is one that sometimes people are told that they absolutely must have, and we hear from a number of clients, financial planners tell them that they absolutely must have that. Carrie, can you tell us a little bit about those trusts?
Well, sure. So an irrevocable trust is a trust that once you have created it, maybe you and your spouse created together, it becomes irrevocable, meaning you can no longer change it. So that's a pretty dramatic step to take. Once you set it up and you put assets into it, you give up your right to also control the trust. You cannot act as the trustee of an irrevocable trust. So you basically give your money away into the hands of somebody else to manage for your lifetime. And all you can get from this trust, once it's set up, you can be the beneficiary for the interest, the income generated by the trust. So if you think about it, if you put $1,000 in, think about how much that earns over a period of time and how much interest you get from your bank. That's how much money you would get from the trust every year, because the principal is off bounds to you. You can't touch it. So it's not really an appropriate estate planning tool unless you have a very large estate and you can afford to live off the interest.
Are there any drawbacks to having this kind of a trust?
Well, the drawbacks of not controlling your own money anymore and not being able to benefit from your own money anymore. It's really just like giving your money away.
That's kind of a scary thought. I know one of the reasons that financial planners and others tell people that they need an irrevocable trust is to prepare for Medicaid. And we had a lot of viewers ask about this. And the question was from a lot of people, is it a good idea to use these trusts to qualify for Medicaid? Dave, what do you think?
Well, these trusts are very specialized, irrevocable. In order to qualify for Medicaid, you have to fit certain standards of assets, and so that's the key. So the idea with these trusts is you put your assets into the trust, and now they become uncountable. In other words, the money according to the guidelines, is not counted. But the problem with the trust is, again, the irrevocability that Carrie talked about, and the fact that to create these trusts to work, the money would have to be in that trust for 5 years. So you put your money in there, you're locked into a time frame of 5 years.
And why is 5 years important?
Well, that's the 5-year look back period. So
on Medicaid.
For eligibility for Medicaid, the Medicaid people look back 5 years to determine if there's been any transfers of assets, because they're afraid that people will move assets around to qualify. So you put the money in the trust. Now you have to wait 5 years before you can apply for Medicaid. Okay, during that time frame, you cannot access your money. That's the problem. So it's a pretty dramatic thing to do. It's a problematic thing, and if you say had to go into a nursing home 2 years later or 3 years later, now you've got a problem because you can't access money to pay for it, and you're not going to qualify for the Medicaid because they're counting that money.
Wow, that's a problem.
So one of the things that you really need to understand is that statistically speaking, only 5 to 10% of people over 65 ever really need long-term care. That's kind of a rarity. So funding that trust within the 5 years and waiting the 5 years, it may well work. But the problem sometimes is Medicaid rules are always changing.
In fact, the look-back period is one of those rules that changed.
That's right. It used to be 3 years. Some years ago it was 3 years. They switched it to a 5-year. For all we know, they could change it on down the road to a 7-year look-back. So what you set up may not necessarily work. So it's important to understand that. Another common problem we see with these types of trusts is that when you're funding a trust with certain assets, there could be tax ramifications and problems. IRAs, 401ks are an example. So if you're going to load up a trust with your big fat IRA that you've been saving your whole lifetime to accumulate, and you put that big chunk of money in there, well, now you're going to be taxed on it. You may even suffer penalties if you're below the age of 55. So it's real important before you go jumping into something like this that you really look at all your options, talk to us about it, and we'll give you the lowdown on how it works and what might work for you depending on your circumstances.
Okay, so you've caused us to be a little bit concerned about using irrevocable trusts for our estate planning. It seems like many of us don't really need them. So maybe we can talk about some other planning tools. And Dave and Carrie have told me that there are other devices that we can use, and that would be joint ownership, beneficiaries on bank accounts and investments, transfer on death deeds, and wills. And so I would like you to go through these with us and explain how we can use them. And let's start with joint ownership. Carrie, what does it mean to own property jointly, and how does this impact estate planning?
Well, when you own a property as a joint owner with another person, it means if you get the deed, you'll see that there are two names on the deed and it says that they own it jointly. Or you'll get a bank statement and it has two names on it, so it's clear that there are two people who have access and the right to use that money and the right to use that property immediately. So most often we use this as an estate planning tool between spouses. In fact, most spouses do it without even talking to an attorney, of course. But we don't usually recommend it so much for if you are thinking of setting up an account jointly with one of your children. And there are a number of reasons for that. Well, number one, if you set up an account jointly with your child, you say his name's John, and John was in a car accident and got sued, his creditor is going to go looking for assets that John owns, and that might include your money in the joint bank account. You could find your money getting garnished by John's creditors, or getting mixed up in his legal affairs if he filed for bankruptcy or a divorce. So that's a risky situation that you can avoid by not having a child as joint owner. The other problem with joint ownership is that often people will add their one child who pays the bills for them. They put John on as a joint owner, but they really expect John to share with all the other kids at the time of your death. And the problem with that is, number one, the law presumes that John is going to be the owner of that money if he outlives you, not the rest of your kids. And that's true even if you have a will or a trust that says something different. So the presumption is that a joint owner owns what's in that account when the first person dies, and that might have an unintended consequences. What happens if John dies right after you die? John's family, John's wife, John's kids may be the ones that end up with that money instead of your other children as you intended. So, and so a lot of times people tell me, well, what can I do? I want John to have access to my money to help pay my bills. And that is exactly what a power of attorney can be used for. So we had another webinar about powers of attorney recently, but a power of attorney is a document that allows you to appoint a substitute decision maker. And that person has legal authority with this paper. They can go to your bank, they can put money into your account, they can take money out, they can pay your bills. But your money is not open to their creditors or their family claims. It'll pass according to beneficiaries or according to your will when you die.
Okay. Speaking of beneficiaries, that's another estate planning tool that you've told us would also help out. So let's start this discussion with a really important question from one of our viewers. Does a beneficiary designation supersede a person listed on a will or trust, Dave?
It does. It's important to understand that when you put a name on as a co-owner, or in this case as a beneficiary, that property will pass directly to the person you name. Life insurance would be the best example of that. You designate a beneficiary on life insurance, you die, the insurance company cuts a check directly to that person. Mm-hmm. The will doesn't cover it, the trust doesn't cover it, it goes directly to that beneficiary. You can put payable on death beneficiaries on pretty much everything. Bank accounts, stocks, bonds. You can do it on IRAs, 401ks. We talked before about the problems with cashing out IRAs and throwing them in trusts. Mm-hmm. You don't have to do that here. You retain it, you control it, it stays in your name. You just name your children as the payable on death beneficiaries. So it works for all different types of assets. Remember, probate involves those things that are just in the name of the deceased. By doing these co-ownership or beneficiary setups, you're avoiding that probate process. Upon the death of the person you've designated, upon your death, the person you've designated then receives those assets directly.
And so if I designate 4 of my kids to receive an asset, all 4 of them would get that?
That's right.
Okay.
That's right.
We have a question from one of our viewers, and he asks, if my son is my named beneficiary, will he automatically inherit my 401k?
Well, if he's on there as the beneficiary, yes, he will. He will get that. He'll then have the option at that point to decide to cash it out or maybe roll it over into an IRA or 401k of his own choosing. So there's a great way to go there. It avoids any probate. It avoids any trust administration. So it's a good approach to estate planning.
Okay. Next thing we want to talk about is transfer and death deeds. Carrie, one of the biggest assets most people have is their home or some other property. And does this always have to go through probate or be put in a trust? Your real property?
No, as a matter of fact, many states allow you to do what are called transfer on death deeds. It's a very popular estate planning tool. In Michigan, you might have heard them called ladybird deeds. Some states call them beneficiary deeds or enhanced life estate deeds. But basically, a deed is the ownership document for a piece of real estate. So if you have a deed in your name and you died right now, it would need to be probated because nobody else has legal rights to sell another person's property. But a ladybird deed, we could prepare these for you. They replace your existing deed. And what it basically says is that you're transferring ownership of your real estate to yourself for as long as you live, and you give yourself full control over the property. So if you decide you want to give it to somebody else or sell it or mortgage it, you have an absolute right to do that. But the deed goes on to say that if you still have the property at your death, ownership is transferred at that time to the people you list on the deed. So you can include one or more people, and they will become the automatic owners at the time of your death. They don't need a trust for that. They don't need probate for that. They don't need to hire a lawyer to help them with that, assuming they can all get along as co-owners. That's one of the key factors to consider. But it's a really nice tool if your state allows you to do that. There are a couple other nice features about it. In the state of Michigan, anyway, if you needed nursing home care and if you were applying for Medicaid, to help pay for your nursing home care, one of the things that they do not count is your residence, as long as the residence is in your own name. So this kind of a deed does preserve your right to claim your property as your residence as an exempt asset for Medicaid eligibility. But the other problem comes up when you die, because if Medicaid has expended money on your nursing home care, they look to recover that money after you die from your family, and they ask to see the deed to your residence. They're looking to see whether the property is going to need probate. If the property passes through probate because yours is the only name on the deed, the state of Michigan becomes a creditor and will seek to recover the money they spent on you. But with a ladybird deed, your family can show that to them and they will drop their claim, and it can pass to your family members with no claim attached from the state of Michigan. Now, we know Medicaid rules do change, so who knows how long that loophole will remain open, but it is there right now.
And how would I find out if the state I reside in allows transfer and death deeds?
Well, again, we'd encourage you to contact us. We'll find, we have attorneys who will advise you about what your state allows and what options you have that meet your particular needs.
Okay, thanks, Carrie. The last estate planning tool we're going to talk about is wills. And Dave, what's a will?
Well, we talked a little bit about wills before. The will is a document that you create. It designates who your loved ones are. It designates who your personal representative will be, your executor or administrator who handles things after you die. And it also sets forth who gets your property after you die. Now, bear in mind, this covers whatever is just in your name when you die. If you already have beneficiaries on stuff, then it'll pass to those people outside of the will. But the will is designed to cover anything that might happen to be in your name at the time that you die. It's a sufficient estate planning tool for most folks. The ironic thing is that even if you do a trust, you do a will. There's always a will along with the trust, the pour-over will as it's called. So the will importantly designates your personal representative, the person who's going to handle things after you do pass on, to make sure that your wishes are carried out and that the property goes to those you've designated in the will. Typically, a person would name a family member as their personal representative or executor, typically one of the children, or it could be any person that you trust. Upon your death, then, those assets are passed on, typically through the probate process, if there is anything just in the name of the deceased.
Mhm.
And again, depending on what there is in this will and how much the value is, that dictates how complicated or time-consuming that might be.
Okay. A question from one of our viewers, and it's, if I have only one child, do I still need a will?
It's always wise to have a will for anybody, no matter how much you have or how small or large your family is. The reason being is you're designating that person that you want to have handle things after you die, so that's not all up in the air and uncertain.
Mhm.
And then, of course, that person will take care of your wishes after you pass on. And as I mentioned before, even with a trust, you're going to do a will.
Okay. And I know the answer to this next question is going to vary from state to state, but how many witnesses do I need for a will, and where do I go to get it notarized?
Well, it does vary from state to state. We're in Michigan here. 2 witnesses are needed. Some states might require a notary on there.
Right.
But if you need to execute a will to have it signed, we can advise you on those things. And usually, in most cases, you can go down the street to your local bank or credit union. They're going to have notary. They're going to have witnesses. And whatever state you're in, they can help you get everything signed if we mail out the documents to you.
So if I go to the bank where I regularly do business, they will usually assist me. That's what we've been finding.
Absolutely.
Yes.
Yeah, absolutely.
All right, good. So after getting all this information, I have to ask, how do I decide what's best for me? In the words of one of our viewers, what's the best way to protect my stuff, Carrie?
The best way to protect your stuff is to create a plan that is suited particularly for you. We encourage you to call us and open a case with us. We will take time to review all of your assets. We'll ask you about your life insurance. We'll ask you about real estate. We'll ask you about your accounts, your 401ks, and we'll give you advice on each one of those things and how best to transfer it to your loved ones. We will determine your family interests, what you want people to share, what you don't want people to share. We'll help you develop create an estate plan that suits you. Please call. Our number, if you call us, is 800-482-7700. That's the number to call to open a new file, and we'll find an attorney in your state to help you create an estate plan.
So we do have a couple questions that have come in, and I'd like to try to address some of those. Is there a provision on a house purchase agreement that covers what a ladybird deed does? Not quite sure what we're getting at there, but is there any issue with, once I have a ladybird deed, with selling my property? I think that might be the question.
Well, the beauty of a ladybird deed is that you have complete control over your property. Okay, you own it, you remain the owner. It's a deed from, say, husband and wife to husband and wife, and the language we use on the deed is for our lifetime, coupled with unrestricted power to sell it, gift it, lease it, mortgage it, or otherwise dispose of the property. But it's still owned by me at the time of my death, then it goes to Tom, Dick, and Harry. You put your kids on there. And then you have free reign to sell it, mortgage it, do anything you want to do with that property. The kids will not be involved in any way, shape, or form if you decide to sell it. So yeah, it's a good way to go, and it's protected from any of their creditors, or if they divorce or anything like that. They only have a future interest that they obtain upon your death.
Okay. We've had a few questions about very specific issues regarding individuals' estate. Again, we would encourage you to call the plan and open a case. That number is 1-800-482-7700. We look forward to serving you. Thank you for participating in today's webinar. Good day.
Thank you.
Thank you.